Hey, how you doing? Welcome back to Man Views. Let's get to it.
My understanding, Ms. Stallings, is that your client did not agree with the findings in the non-agreed child support review order with respect to the arrearage or ongoing child support. Is that pretty much sums up what the objection was?
Yes, Your Honor. I don't believe that their number comports with their pleading. It's a significantly lower amount, and under Rule 301 of the Texas Rules of Civil Procedure, a judgment must comport with the pleadings.
All right, enough. If you will present your case, please.
Firstly, I'd ask the court to take judicial notice of the 2007 divorce decree, which outlined the initial child support obligation in this case.
All right. Any objection, counsel?
I don't object to the court taking judicial notice of that decree. I do find that there are some irregularities in that decree, which I will raise in our defense.
All right. Okay. The court notice of the underlying court order, which in this case is a divorce decree that was entered back in 2007. It is in the court file and does appear to be in proper form, duly signed by the appropriate judicial officer in the referring court at this time. Go ahead, Mr. Knopf.
At this time, the state will offer its updated financial activity report. This is the financial report of all payments which have been received on the case by the OAG. I'll be dropping it in the Zoom chat for everybody to see. And if you got a computer, you should be able to just go to the chat window and download it.
Well, I don't know if I can. I'll just ask some questions. Can you tell me what the total number of payments have been made?
So our total cash applied, I believe, comes out to $6,841.75. So we've got a total owed before we apply payments of over the life of the case of $44,373.85 minus payments made comes out to a balance as of yesterday of $37,532.10.
We don't agree with that number, but thank you for telling me your numbers.
And counsel, would you have any objection to us entering this in evidence just so that we have a starting point to discuss for our discussion of what monies are or are not owed?
No, I have no objection to it being entered as your exhibit for what you claim is owed.
Okay. In which case, I'm going to call Mr. Samir Elbo. Sir,
yes.
Could you please state your name for the court?
Okay, my name is Elbo Samir, or Samir Elbo.
And sir, have you had a chance to look at the state's financial activity report for this case?
No, I don't believe I did.
With the court's permission, I'd like to screen share it now just so that you can take a look at it.
Okay.
All right, go ahead. Yes, sir, go ahead.
All right. It says host has disabled participant screen sharing.
Oh.
Yes.
Right, well, go ahead, Mr. Knopf. I mean, you summarized what the document reportedly says.
Okay. Mr. Samir, would you agree with the calculations that the OAG just stated as the true and correct accounting of monies owed on this case?
Yes, sir.
So you've received $6,841.75 in child support since the prior order.
I don't know if I received that much, I think it's less than that, but maybe I don't really count. I receive about $113 every 2 weeks, I think, for the last year or so. So how did it come to 6,000? I don't understand.
Having received, and so this is just me describing the document, and counsel call me out if I'm, mischaracterizing it. But it looks to be about $113.82 was received starting in February of 2019 and continuing about twice monthly thereafter up until the present time.
Yes, sir.
Is that about an accurate depiction of money you've been receiving on this case since that time?
Yes. Yes, sir.
Would you agree with the OAG's calculated total of money still owed on this case for $37,532.10?
Yes, sir.
At this time, the state would offer Exhibit 1 into evidence.
Objection, counsel?
Your Honor, I don't have a problem with them being admitted as a summary of Mr. Elbo's testimony. We disagree with the figures, but again, that's a summary of his testimony. I have no objection to.
All right, okay. I'll note that objection. However, as provided in Texas Family Code, I will admit the updated financial report subject to any other testimony that counsel may have. Go ahead, Mr.
Mr. Samir, have you received any direct payments from Ms. Albas that didn't come through the state disbursement unit?
No, sir. Not a penny. Absolutely not.
Get that last part, ma'am. Sir, what was your last part?
No, N-O. No, sir.
Okay, well, you said something else after that.
I said absolutely nothing. Oh,
Okay, all right, thank you, sir. Go
thank
ahead.
you, sir.
Do you know where Ms. Albas is working at this time?
I believe at Walmart at Fort Worth.
And how do you know that information?
I was told by the Attorney General.
Do you have any idea what she might be making at this time, based on your personal knowledge?
I believe that the Attorney General told me about.
Objection, hearsay, Your Honor.
I'll sustain the objection.
Okay.
Mr. Elbo, you can only testify as to those matters that you know of from personal knowledge. Okay,
I don't know.
go
I
ahead,
don't know.
Tony.
Do you know if Ms. Albas has any outside assets besides her normal job that could provide her income?
I don't know.
And I don't think there was an objection to health insurance coverage, so I think that issue will stay from the confirmation order previous. This time I'll pass the witness.
Ms. Collins, any questions?
Yes, Your Honor, if I may.
Yes, ma'am.
Mr. Elbo, in your divorce decree, which has been admitted into evidence as the court took judicial notice of, I don't know if you still have a copy of that before you, but I have a certified copy before me, and the court and opposing the AG's office can look at that. It appears that page 10 of that document is the page that talks about child support. And I represent to the court and to Mr. Elbo that I am looking at page 10. Initially, did you and your ex-wife have an agreement that she would not pay any child support and that you would not pay her any child support?
It was an agreed yes in the beginning. Yes.
Okay. And it appears that page 10 of the divorce decree at the top of that document shows that it was faxed back to between the two attorneys on November 15th, 2006. And it says that that is page 4 of that fax document. Do you have any reason to dispute what I'm asking the court and the OAG to look at? I mean, that's what it says.
No.
Okay. And that's the document that it says that it is ordered that each party will support the children financially while in his or her possession, and that neither party will pay child support to the other party for the children's financial support. That was your agreement, was it not?
No, it was rejected by the judge.
Okay. So was it rejected in March of 2007? When the court signed the order?
I think, I cannot recall the exact date, but I know that the judge said this is not gonna fly.
Okay. And do you have any personal knowledge of whether or not my client agreed to the change where it's handwritten in that she's to pay child support of 3 different amounts. Do you have?
Okay. I'll tell you what. On that original agreement, it was based on each one of us will have equal custody of the kids. But once she dumped all the kids on me, the whole agreement changed.
Okay, on that same page 10 for the court and opposing counsel's information, it talked about visitation, and it says that she's going to have, at first it had supervised visitation, and then it had standard possession order. Mr. Elbo, was it your understanding that she was to have some kind of standard possession of these children by the time this case finalized?
It's my understanding that each one of us will have equal time of custody with the kids. That's why each one of us will take care financially of them, because the kids is going to live equal times with each one of us. But once she decided to leave the country, the whole things change, which means that I'm going to have 100% custody of the kids, which means I will have the 100% financial responsibility of the kids.
Okay, getting back to my original question, do you have any knowledge that my client agreed and signed off on the child support that's ordered in this document? Was she even in the country on March the 9th of 2007?
I think she just bailed out completely.
So your answer is no. She was
no.
not present in the country at the time that this order was entered.
Yes, that's exactly right.
And you have no knowledge whether or not she was ever made aware that she was ordered to pay child support, do you?
Yes, she knows.
No, but was she made aware, and did she agree to the payment of child support on March the 9th, 2007?
I don't know. I don't know about it.
Okay. Also on that same document, her signature appears on what is labeled page 33, which is the final page of your divorce decree. And I would call the court's attention to the top of that page. And it says that it was sent in on November 15th, 2006, some 5 months before the document, which appears to be now a 33-page document, was entered by this court.
Actually, she split. She left and she's nowhere to be found. And the judge ordered her attorney to find her, and he just couldn't,
Your Honor, I'm going to object as there not being a question before the witness.
Well, it is the answer. I know you don't want to hear it, but this is the answer, ma'am.
Your Honor, objection, non-responsive. There's no question.
All right, Mr. Elbo, just wait until the question is being asked. If you don't understand the question, ask that it be phrased, okay?
Yes, Your Honor.
Okay, thank you. Go ahead, counsel.
After my client went to Jordan, did she call the children ever?
No, ma'am.
She never called. Isn't it true that she called the children at least 3 times from Jordan and spoke to them each time for approximately 15 minutes?
No, ma'am.
Okay.
No, ma'am.
And during
I think somebody, called, I believe it's her mom, but I told her mom, what, if she want to talk to them, she can talk to them, you cannot talk on her behalf.
Okay.
But she never, and she came to Dallas and she never even tried to call them.
I'm saying specifically after she went to Jordan, isn't it true she made at least 3 telephone calls and talked with you and your children?
No, ma'am.
Okay. I will pass this witness.
All right, Mr. Knopf, any other questions for Mr. Elbo?
Not at this time. However, I would like to call Ms. Albas to get a little more information.
I'm sorry, who?
Ms. Shadia Albas. I apologize about my pronunciation.
Okay.
Ma'am, could you please state your name for the court?
Yes, my name is Shadia Albas.
And Where are you working presently?
In Walmart, in Fort Worth, Walmart.
How much are they paying you an hour?
Per hour. It's 11 and 20. It was 11.44 right now since month ago, and before it's 11.22.
And how many hours a week are you getting right now?
Between 35 to 40.
I'm sorry, come again?
35 to 40. Each week is different. Sometimes it's 35, sometimes 34, and sometimes it's 40.
So just doing a quick average here, the average of 25 and 40 comes out to 32.5. Is that an average week for you, or is your average week above or below that?
Yes,
So 32.5 hours a week is normal?
An average.
yes, yes.
Okay. And do you have any outside sources of income
No, sir.
besides your normal job?
No, this is the only job.
Say again?
No, this is the only job.
And you are an employee with Walmart?
Yes, sir.
I'll pass the witness.
All right. Counsel, any questions?
Yes, Your Honor. Ms. Albas, have all of your kids graduated from high school at this point?
Yes, ma'am. Yes,
So there are no children that you owe an obligation of support to, isn't that correct?
yes, ma'am.
Okay. And I'm going to refer you to the pleadings that we've discussed at length. This non-agreed support says that on page 2, child support was to begin on 3/1/2014 and monthly thereafter. Is that correct? That's what they served us with.
Yes,
Okay. And based on computations of $161.61 beginning March 1st, 2014 as pled, did I put it in a program similar to what the Texas Attorney General uses and calculate that your child support based on their pleadings would be $11,312.70.
yes, ma'am.
Okay. And now you came back to the United States and began working in Walmart in approximately September of 2018. Is that correct?
Yes, ma'am.
And did we go through your pay stubs to see that they started taking child support out of your check and the first payment was on September 23rd, 2018?
Yes, ma'am.
And was that payment in the amount of $108?
$108, yes, ma'am.
Okay. And does our pay calculation show that amount coming out of your check every 2 weeks thereafter until we ran this back at the time that you were served, which was through December 15th of 2019. Is that correct?
Yes, ma'am.
Okay. And just recently, within the last month, did you receive a new wage withholding order at Walmart?
At what? I'm sorry?
Did I just inform you that they sent a new wage withholding order to your employer?
Yes, ma'am. Yes,
And was that in the amount of $50 per month?
yes, ma'am.
Okay. And in addition to payments that you've made since December 15th of 2019, did they also confiscate and take from you $763 in the form of your 2018 tax refund?
Yes, ma'am.
And do you show that on our calculations as that was not included? Is that correct? $763 even for 2018.
Yes.
Okay. And in 2019, did they take your tax refund in the amount of $1,005?
Yes, ma'am.
Okay. And then more recently, in fact, your letter was dated May the 8th of 2020. Did they take your $1,200 stimulus check?
Yes, ma'am.
So based on our calculations, do you believe the correct amount of child support arrears based on the pleadings would be a number of about $6,249?
Yes, ma'am.
Do you have any objection to the court rendering an order that says that you owe $6,249?
No.
No,
No.
is that correct? Right. And you're willing to continue paying that from your wages, is that correct?
Yes, ma'am.
Let me ask you regarding your divorce decree, and I know you have a copy of it before you, and we've discussed this some. Do you recognize your signature, which now appears on page 33 of that divorce decree?
Which page, ma'am? I'm sorry.
It's the final page, page 33 at the bottom right. It says page 33.
Yes, this is, yes, ma'am.
Okay. And do you also see at the top of that document where it was faxed to a law office on November 15th, 2006 at 2:26 p.m.?
Yes, ma'am.
And it says that's page 5 of your document.
Yes, ma'am.
Okay. And in your same divorce decree, I believe it was on page 10.
Okay, yes, ma'am.
Okay. This was at the top, it says this was page 4 of a document that you agreed to. Is that correct?
Does that mean it's my signature?
No, I'm saying, does at the top of that say it was faxed on November 15th, 2006 at 2:26 p.m. and it's page 4?
Yes, ma'am.
Okay. When you agreed to this document, did it have all this extra writing on it?
No.
Were you ever consulted with or made aware of changes made to this final divorce decree prior to 2015?
No, ma'am. No.
And in 2015, where were you living?
2015 in Jordan.
Okay. And right after signing what appears now as page 33 of this document in November of 2006, where were you living?
2006
Yes.
in Fort Worth here, and it's my sister.
So at the time that you agreed to this, you moved from El Paso to the Metroplex. Is that correct?
Yes, ma'am.
And when did you leave to go to Jordan?
With my mom.
Okay. What time? Was that in February of 2007?
Yes, ma'am. In February 2007. Yes.
Okay. So you were not even in this country when this divorce decree, which says on the front page it was agreed to on March the 9th, but it wasn't signed by the court until November or March 16th of 2007. You were not in this country at that time, were you?
Yes, ma'am.
Okay. So you were already in the country of Jordan.
Jordan, yes.
And did you ever attempt to contact your ex-husband and your children after you moved to Jordan?
Yes, ma'am.
Okay. And do you recall how many times you called?
I called 3 times, ma'am. I'm talking with my kids.
3 times that you actually got to speak with your children.
Yes, ma'am.
Okay. During those phone calls, was your ex-husband present?
What the number you mean?
Like when you called to speak to your children, was their father there?
Yes, I talking to him before, and then he gave me the kids to talk to him.
Okay.
With my daughter Dalia and Hisham, and the last one is Dina. I talked to him, both of the 3 of them.
And at any time during any of those conversations that you had from Jordan, was there ever a mention that you owed child support?
No, he didn't.
You believed that your agreement was that each of you would just take care of the children when you had them. Is that correct?
Yes, ma'am.
Okay. And at no time until you were coming back to the United States were you notified that there was a child support obligation, correct?
Yes, ma'am.
Now, they attempted to do this child support review on January 23rd of 2020. Is that correct? The document that we're talking about today is January 23rd of 2020.
Yes.
Okay. And at that time, you were working at Walmart.
Yes, ma'am.
Do you recall exactly how much you were making back in January of 2020?
By the hours or
By the hour.
by the hours, it's about 37 to 35 to
Now, how much per hour? What is your hourly rate?
11.22 per hour.
And in this computation, you objected to their calculation because they used 40 hours. Is that correct? They showed your grossly month resources as almost $2,000, correct?
Yes, ma'am.
And we've already established that it was much less than that, right? Okay. You're not opposed to paying child support for January or for February, March, April, and May until your youngest child graduated. Is that right?
Yes, ma'am.
So you're all right with the court calculating child support for the 4 months since you were given notice of this?
Yes, ma'am.
Okay. But you believe that you owe somewhere in the neighborhood of $6,249.94, correct?
Yes.
So on page 11 of their proposed document, because they have the wrong number of hours and the wrong amount of your wages, you don't agree that how much you should pay is $323. Is that correct?
Yes, ma'am.
Do you believe it should be no more than $299 a month?
How much, ma'am?
$299 would be the maximum amount that you think it should be?
Yes.
Okay, and you understand that you might have to pay a little bit more than that to pay off now, which would all be an arrearage judgment. Is that right?
Yes.
The document that the court has taken judicial notice of, your final decree of divorce, did you agree to that document as it's currently in the court's jacket? In other words, you never agreed to pay him child support. Is that right?
Yes, ma'am.
And you learned of the mistake while you were still in Jordan. Is that right?
Yes.
Okay. And you came back to the United States in the fall of 2018?
Yes.
And at that point, did they tell you that your passport was suspended?
Yes, ma'am.
And you've been unable to travel since that time, is that right?
Yes. Yes.
When you were in Jordan, who were you living with?
With my mom.
Okay. And is she an elderly person at this point?
Yes, ma'am.
And is she in good or bad health?
Yes, it's bad right now.
And are you concerned that if something were to happen to your mother, that you would be unable to go back to Jordan to care for her?
Yes, ma'am.
Or heaven forbid, if she were to pass away, you'd be unable to go back to attend her funeral?
Yes, ma'am. Sure.
Are you asking the court to render a judgment that includes the amount that we have calculated based on the pleadings of the state and 4 months of child support at $299?
Yes, ma'am.
I'll pass the witness.
All right, Mr. Knopf?
No further question. State will rest subject to a brief closing argument.
Okay. Ms. Collins, any other evidence or testimony?
No, Your Honor.
Okay. All right, I do have some questions for Mr. Elbo. Mr. Elbo, your youngest daughter, Dina, is that right?
Yes, sir.
When did she turn 18?
November 6 of last year.
Okay. And in 2020, was she attending school, high school?
Yes, sir. She graduated on May 30.
She graduated May 30. What high school did she attend?
Okay, Montwood High School in El Paso, Texas.
Montwood. Okay. Mr. Elbo, concerning the divorce decree, did you have an attorney representing you?
Yes, sir.
You know, Ms. Albas had an attorney representing her.
Yes, sir.
When the divorce decree was signed before the judge, does your signature and hers appear in the order?
I know my signature, but I know that the judge ordered something, ordered the minimum like child support for the kids based on the state of Texas,
Okay,
but I don't know.
My question, sir, is did you sign the decree of divorce?
Oh, yes. Yes, I did.
Did your attorney sign the decree of divorce?
Is my attorney or her attorney?
Okay, well, for the record, I am looking at the divorce decree in the last page, the signature page, which does have the signature of the judge, 2 attorneys, 1 for each of the parties, and the parties themselves. Their signature does appear in the order that was signed by the court back in, I believe it was in March of 2016.
Yes, sir.
2007, I think. Okay. All right, that's all the questions I have for Mr. Elbo. Any follow-up questions on the areas the court touched upon with Mr. Elbo? Mr. Knopf?
None, sir.
Ms. Stallings?
No, sir.
Okay, all right. State's recommendation on this matter.
State recommends that child support be set based on Ms. Albas's then current monthly wages. Again, that we're kind of going back in time here a little bit since this negotiation was carried out in January. At that time, state calculates she was making approximately $1,580.15 a month. And therefore, the state will recommend that child support be set at a rate of $267 per month and medical at $71 per month, starting February 1st, 2020. The state is going to recommend that there be a judgment on the arrears as of December 31st, 2019, based on the financial activity report and the calculations therein, in the amount of $39,479.26, and recommends that payback be set on that past due amount at $200 per month. I calculate that interest is accruing on that amount at $197 per month. However, I think setting it much higher than $200 might impose an undue financial hardship on Ms. Albas. That said, if the court does go with Ms. Stallings' calculation of the arrears, I believe the amount was $6,249 in a past due child support, that payback be set on that at least $82 per month, if the court goes with that calculation. I will point out that if Ms. Stallings is alleging extrinsic fraud, procedural misconduct, or just an overt mistake on the face of the previous order, that's really should be in the form of a bill of review. I don't think there's sufficient pleadings to sustain that kind of collateral attack on the prior order. And if they're going to allege the signature was a fraud, I don't know that that's been proven up properly. Thus, the state is going to say that the 2007 order should be viewed as the correct means of determining child support from that point up. I don't think there was any pleading for non-disclosure, and I don't think parties were contesting medical coverage, so that'll be everything from the state.
Okay. I do have a question, Mr. Knopf. There's been some testimony concerning some offsets. I know you all don't like to talk about offsets, and I know you also don't like to talk about any other kind of offsets, such as the stimulus. Is there any? I really did have a have a problem in accessing the financial report. It, for some reason, didn't look like the normal financial report. My question is that any of those offsets, were those or were there those intercepts applied to the petition or to the accounting? I understand maybe Mr. Elbo didn't receive them, but if they were applied.
So we definitely got a federal offset as of April of this year, which is applied, I think, on 4/20/21 thereabouts. And then looks like we've got another one for May 18th, which is reflected. Let me make sure that's included on the financial record. Yes, if you look towards the bottom of the second to last page, I think we've got that reflected there as well.
Okay. So,
And Your Honor, I have a question. Can he verify, since I haven't been able to open my document, whether or not they received the $763 offset for 2019? The letter from the Treasury was dated 4/19/19, so it would probably been the end of April or the beginning of May in 2019 for $763.
I am seeing an entry dated 5/3/2019, which is labeled as federal offset collection in the amount of $763,
Okay.
which is applied.
there was some testimony, I think, that was brought up, and this is news to me. Can you all intercept the stimulus checks?
Oh, yes, absolutely, sir.
Oh, that's news to me. All right. Okay, and that was that's also reflected in the updated financial report that there was a stimulus check that was in it.
I believe that's, oh, apologies. I believe that's the 1,200 that we have listed as of 5/18/2020.
Okay, all right. Thank you, sir. All right. Installments?
Yes, Your Honor, thank you so much. Again, because their pleadings say that they're asking for child support beginning on 3/1/2014, and that's on page 2, referencing the prior order. Texas Rules of Civil Procedure 301 state that the court's jurisdiction to render judgment is invoked by pleadings, and the judgment unsupported by pleadings is void. Ex parte Fleming 532 Southwest 2nd 122. That's a no writ case. I believe that they cannot collect the child support prior to 3/1/2014 because their pleadings don't support that. And therefore, my calculations of child support would be the correct amount for the arrears. I think I was not pleading because I don't think I can do a bill review at this late date. My testimony regarding the discrepancies in the final divorce decree just brings into focus that this was not agreement. It says on page 1 that Shadia Albas did not appear, and it does not reference that she has an attorney. She was never notified that an attorney signed off on this document, and certainly page 10 of that divorce decree and page 33 of that divorce decree raise the issue that this signature and a person signing off, Roberto Sanchez, as her attorney of record may have been from a temporary order, and that's dated November of 2006. And that coupled with the fact that the state's pleadings don't support a judgment going that far back is my argument and my belief that this court cannot render a judgment for anything prior to 3/1/2014. And therefore the dollar amounts that I gave are the correct numbers.
All right. Anything else, Ms. Stallings?
Well, and the state testified that they wanted their judgment as of December 31st or December 30th, 2019. And that I have an exact number for that time. If the court will give me one moment. I didn't have an updated pay record, but I show, since there were no more payments after December 15th of 2019, that the amount that she owed was actually $9,654, but that did not include her two tax returns and her stimulus payment, which I deducted and then estimated a couple of $100 in payments that she would have made in January, February, March, and April and May, and I guess now June and July of 2020. I did not have that information before me. So again, I still think that my calculation is accurate, very accurate, or as close as we can get at 6,249 without us actually getting out a calculator and subtracting out those payments.
All right, Mr. Knopf, any response? Any other argument?
I think our previous argument holds. I would just like to add that the reference to the child support in the amount of $161.61 starting May of 2014, that was just using the step downs. We are not referencing any other order. It's still derived from the 2007 order properly noticed. I think our pleadings do sustain a judgment on the arrears in the full amount from the prior order.
I might respond. Their only pleading in this case is their child support review order, which they're asking you to take. And the only reference in there says child support beginning 3/1/2014, which that number would have no basis of in fact or in anything else, except for that is what they pled. And the rules of civil procedure are very clear that if you don't plead it, you don't get it. They didn't plead it, they don't get it. Any judgment rendered for anything more than what they pled is void. Case law is very clear, and there's no problem with that. If you don't plead it, you don't get it, and anything rendered that's contrary to their pleadings is not just voidable, it's void. So anything other than what they pled is not a valid judgment.
All right, Mr. Knopf, okay, I have, can you clear something up for me? You're asking alternative judgment states. Are we confirming the arrearage as of June 30th of this year, or your other argument was to confirm it as of the end of December of last year? If we do that, if that's done, how would the numbers change as far as the ongoing child support start date and things of that nature?
So the numbers I provided were
normally to confirm as of the last previous month.
Yes, in this case, since the prior negotiated order was referencing December 31st, 2019, I went ahead and used those numbers. If we were to go with the last day of last month from today, that would come out to, oh, Texas, why do you have to give me these problems? Apologies, just bringing up the case. So that would come out to 37,000.
Your arrears as of December 31st as pled.
December 31st?
Of 2019.
So that'll be $39,479.26.
Now, there's also a question that came up during the testimony of the non-custodial parent. Has there been a recent wage withholding order sent to her employer?
It looks like a new wage withholding order went out May 31st of 2020, and that was to reflect the drop down in payments due to the eldest child graduating.
Okay.
And it looks like it reduced it, it asked for payments in the amount of $85 a month to be paid just towards the arrears.
Where did the $85 come from?
I think it was just a continuation under the prior administrative income withholding order. They had $161 as her primary payment, and then the 85 got tacked on to add to just address arrears. In this case, I don't think they were factoring it based on her current wages. I think they just dropped the primary support payment and just continued forward with the secondary payment.
Okay, I just want to make sure that y'all didn't send out a wage withholding order based on the new order that hasn't even been signed by the court.
No, we did not, sir.
Okay, all right. And so the new withholding order, since the child is already emancipated, would not have ongoing child support and no ongoing medical support?
It doesn't have either. It just has a payment towards arrears of $85 per month.
$85 a month. Okay. All right. Okay. I just want to make sure that we're doing what we need to do as far as new obligations. Okay. All right. Having heard testimony, I will confirm the judgment. I will amend the child support review order. However, I will confirm the arrearage as of December 31st to be $39,479.00. I will order that Ms. Albas pay that judgment off at a rate of $100 a month. And I know that's below the interest going to be charged, but given the circumstances, I don't think she can afford anything more, and I don't want to create any more hardship for her. Child support and medical support obligations have ceased due to the emancipation and graduation of the child. So I'm amending the child support, non-agreed child support review order in that respect. Although, yes, okay. Just make sure that the child support that was previously ordered is not continuing since the graduation of the child. The child support that was set in the child support review order of $200.
But that's
$323. Was that the child support that was set in the non-agreed?
it is, and that their testimony was that it should be much lower than that.
I know, but I'm asking what the order said.
The original non-agreed order asked for $323 of child support starting February 1st, 2020 and monthly thereafter. It also asked for medical in the amount of $88 per month as of the same date.
Right. I'm going to amend the child support order to be $200 a month. That's the other amendment on the child support review order.
Will medical support remain the same?
Yes, sir. Up until the time of graduation. Okay. All right. Any other questions? Ms. Stallings, you raised the issue on the passport. Unfortunately, I have no authority on that issue. That issue needs to be addressed through the federal government. They're the ones that can issue and can issue or suspend passports. I have no authority over that.
Your Honor, I guess my question still boils down to Texas Rule of Civil Procedure 301. There are no pleadings that ask for child support prior to April the 1st of 2014 on page 2. The only thing in the non-agreed support order, they didn't ask for money going all the way back to 2007. And therefore, I don't know how this court, the law says that your order will be void. I'm asking the court to look at page 2 prior order. They only pled $161.61 monthly beginning March the 1st, 2014 and monthly thereafter.
Well, I made my ruling. You can certainly raise that on appeal if that's what you wish to do. My ruling here today is stated already under the Texas Family Code. You have 3 days from today's date to file an appeal with the referring court, which in this case, I believe is the 65th District Court, if I'm not mistaken, here in El Paso, Texas. Right. Anything else, Mr. Knopf, Ms. Stallings? Do you have enough information for the order?
Yes, sir. And I believe we've got entry set for July 16th.
Okay, well, All right, Ms. Stallings, would you like the AG to send you the proposed order before I sign it, or you want to review and make sure it's as I ordered it, or can I sign it without your signature?
I'd like to look at it. I'm not sure if my 3 days begins when I get that order, if it's not set for signature until July the 16th, which is what, 2 days from now?
Okay. All right,
I would,
Mr. We'll go ahead and prepare the order and send it to you. Our normal procedure is we do a DocuSign.
that's fine.
They will send it on to you. And I anticipate that he'll probably be able to do it sometime, today. I'm giving you some deadlines, Mr. Knopf. Go ahead and send it to Ms. Stallings. You have her email address.
I don't know that I do. Could I get that from you real quick?
Absolutely. It's DMSnotice, NOTICE, at gmail.com.
Gmail.com. Got it.
Okay. All right. Okay. Unless there's anything else, I will conclude our hearing for today. I do appreciate y'all's participation and courtesy in this matter. At this point in time, I'll terminate the hearing and let you all go. Thank you all very much.
Thank you.
Okay, that's the end of the court hearing. But man, can you imagine if a father did what that mother did? That's all I'm gonna say. I'm gonna let y'all comment below your own thoughts and dialogue. Don't forget to like the video, share the video. As always, subscribe. See y'all next time.